Good morning, everyone.
Good morning, Judge.
Good morning, Your Honor.
All right. So you guys ready to get started?
Yes, sir.
Yes.
Okay, let's go on the record on DC 216088. Counsel, make your appearances.
Rachel Hyken, attorney for Heath Cleveland and Sabas Peter Perez II.
Your Honor, I'm Jeremy Watson for the plaintiffs collectively.
All right, you may proceed.
Okay, Your Honor. Because it's a little bit difficult for you to stare at a talking head for 30 minutes, I put together a short presentation. Let me see if I can share my screen. If not, I can just
Go ahead.
without the PowerPoint. Let's see. You know what? I don't know that I have the share screen option right now.
You do.
I do.
I just enabled it.
Oh, great. Okay, perfect. All right, Your Honor. We're here today on defendant's motion for summary judgment in this case. The property at issue, Your Honor, is located in Oak Cliff at 2127 Severs Avenue. Back in 2018 and for decades before, it was a vacant lot burdened with ad valorem tax liens and other encumbrances. In September of 2018, a deed from then record title holder Dora Mae Thompson Jones to Tres Bendiciones LLC was recorded in the real property records. In April of 2019, Manuel Posada Leon contracted to purchase the lot from Tres Bendiciones, and he closed the next month at a title company, Capital Title of Texas LLC, paying a little bit more than the CAD value for the property, in other words, $40,000. Mr. Leon constructed a new 4-bedroom house on the lot. And although plaintiff Deborah Ray Jones saw the foundation for the new house had been poured, she made no attempt to make Leon aware of a forgery in his chain of title or to stop him from constructing the house. The following year, in March 2020, Mr. Leon contracted to sell the property to defendants Cleveland and Perez. On April 15th, 2020.
I've actually read all of this, so you're kind of hitting stuff I've already.
Okay.
Kind of just regurgitating, I think, the pleadings or so why don't you kind of get to the meat?
Yes, Your Honor. Happy to do that. So Mr. Cleveland and Mr. Perez purchased the property for $235,000. Obviously, we're here for a reason, Your Honor. There was a forgery in the chain that Mr. Leon, Mr. Perez, and Mr. Cleveland had no knowledge of. We admit that Dora Mae Thompson Jones died in 1998, meaning she couldn't have signed that 2018 deed. But there was nothing in the real property records that made us aware of the forgery or Mr. Leon, Mr. Cleveland, and Perez of the forgery. And prior to the suit, they had no knowledge that there was a defect in their title. In May of 2021, the Jones heirs, so this is more than a year after the house has been constructed and Mr. Cleveland and Mr. Perez have paid now $235,000 for the property, the Jones heirs filed a suit for trespass to try title and declaratory judgment and quiet title, seeking title, possession, and damages against Mr. Cleveland and Mr. Perez. Mr. Cleveland and Perez counterclaim, and they counterclaim, of course, under the good faith improver portion of the statute and also under the good faith improver common law. We are here on the motion for summary judgment to do 3 things. 1, to establish Mr. Cleveland and Mr. Perez's right to recover for the improvements made to the property, saving for trial the amount of the value of those improvements, to obtain a take-nothing judgment against the Jones heirs on their right to offset for use or possession, because on the no evidence portion of our motion, they have not adduced any evidence that the property had any rental value outside of the improvements. And number 3, to establish that attorney's fees are unavailable as a matter of law to the Jones heirs because the property sounds in trespass to try title and quiet title. And as the cases have uniformly said, especially the Texas Supreme Court and Dallas Court of Appeals case, attorney's fees are not available to decide incidental issues to those actions. So the good faith improver claim, Your Honor, I think you're aware, is an ancient doctrine. It literally precedes the state of Texas, dating back to Roman times, and was adopted under principles of Spanish law. It's been recognized as a law in the state of Texas since literally before Texas became a state, and has always been observed and now has been codified in Chapter 22 of the Texas Property Code. So there's basically a formula. On one hand, you've got the enhanced value due to the improvements, and as an offset, the use and occupation based on the property condition prior to the improvements, which here would be the raw land. So a defendant in a trespass to try title action who's not the rightful owner, in other words, cannot be dispossessed from the property until the plaintiff has satisfied the good faith improver claim by paying the amount of those good faith improvements into the court's registry. And if the plaintiff fails to pay the good faith improver claim within 1 year of judgment, then the defendant can compensate the plaintiff for here the land value, and the defendant gets title to the property. So Cleveland and Perez here are good faith improvers. The undisputed evidence shows that Mr. Leon built a single family home with 4 bedrooms, 3 baths, a dining area, a kitchen, that he poured a new driveway and a new walkway. Cleveland and Perez added a carport, a dog run, poured a slab in a shed, extended the driveway, improved the fence, had a plumber add a gas line for a stove, installed gutters and window treatments. The Jones heirs erroneously contend that there's no evidence these improvements enhance the value of the property. But of course, the summary judgment evidence shows that Cleveland and Perez paid $235,000 for the property when they purchased it less than a year after Leon bought the raw land for $40,000. Now, on the offset issue, you have to keep in mind that the offset that the plaintiffs are entitled to is limited to the property in its vacant land state. Courts have awarded a $0 offset, whereas here the property was raw wild land, and the plaintiffs failed to offer evidence that it had a rental value without the improvements. So because the Jones heirs have offered no evidence the property has rental value outside of the improvements, they are not entitled to any offset. And their citations to malicious trespass cases don't change, of course, the result, because this is not a trespass case, it is a good faith improver claim. And the Texas statute says that the plaintiffs are not even entitled to dispossess defendants from the property until they have paid that good faith improvement sum into the registry of the court. On the attorney,
can you show in the statute, can you share screen that exactly what the statute says about the paying into the court's registry?
Yes, let me pull it up for a second. Hang on, Your Honor. Okay. All right, Your Honor, this is section 22.022 of the Texas Property Code, which says if in a trespass to try title action, the plaintiff obtains a judgment for the contested property, but the defendant obtains a judgment for the value of the improvements in excess of the defendant's liability for use, occupation, and damages, the court may not issue a writ of possession until the first anniversary of the judgment unless the plaintiff pays to the clerk of the court for the benefit of the defendant the amount of the judgment in favor of the defendant plus interest. And then it goes on to say in 22.023, if after a trespass to try to title action, a plaintiff does not pay a judgment awarded to a defendant plus accrued interest before the first anniversary of the judgment, and if the defendant before the 6th month after the first anniversary of the judgment pays the value of the property less the improvements to the clerk of the court for the benefit of the plaintiff may not obtain a writ of possession ever, or maintain any proceeding against defendant or the defendant's heirs or assigns for the property awarded to the plaintiff in the trespass to try title action. So that's where the 6-month period is, Your Honor, for the defendant to pay for the raw value. And then lastly, it says if an eligible defendant does not exercise that option, then a plaintiff can apply for a writ of possession as in other cases. So there's an interesting equitable sort of regime that's created here that gives the plaintiff the first opportunity to pay for the good faith improvements. If that year expires and the plaintiff hasn't done that, defendant gets 6 months to pay for the raw land. And if defendant fails to do that, then plaintiff can dispossess the defendant and sell the property or do whatever and has rights. But basically that's the regime, Your Honor.
Okay.
All right. Okay, so the last thing, Your Honor, is, of course, on the attorney's fees issue. The Jones heirs are not entitled to attorney's fees. We've included citations to both Texas Supreme Court authority and to Sandy versus Powell, which is a Texas Court of Appeals case out of Dallas, in which a very, very similar set of allegations were raised in connection with a declaratory judgment action. In Sandy versus Powell, the Dallas Court of Appeals considered that a declaratory judgment action which sought to declare the sheriff's deed to purchase void and of no force and effect, and to declare that all right, title, and interest in the proper title ownership to the property remains and vests with plaintiff. This is almost exactly identical to the pleadings here. Applying Martin versus Ammerman, the Dallas Court of Appeals held that those allegations involved the establishment and clearing of title, and therefore the attorney's fees as a matter of law weren't available. Here, the Jones heirs seek to determine deed validity, the right to possession, and title. The nature of their action sounds in trespass to try title and in quiet title, and for the reasons stated in Coinmock, Sandy versus Powell, and Martin versus Ammerman, and AMC Mortgage Services, Inc., which are all discussed at greater length in our reply and motion for summary judgment, they're not entitled to attorney's fees. The legislature has provided that Chapter 22 of the Texas Property Code is the method of determining title to real property. And because the legislature didn't provide for attorney's fees in that statute, attorney's fees are not available through the declaratory judgment statute. One thing I'll note, Your Honor, is that this case or motion was previously set for hearing a month ago, and we raised in our reply an issue relating to the timeliness of the response that's no longer relevant. We're not relying on that argument in any form or fashion. Your Honor, you can ignore that portion of our reply brief.
Okay.
So in conclusion, at the beginning of the story, there was a neglected lot with about $25,000 worth of equity. The Jones heirs now seek a gigantic windfall. Despite sitting idle and watching this house being built, doing nothing to prevent the house from being constructed, while a good faith improver paid to purchase the property, cleanse it of encumbrances, improve it. Now the Jones heirs claim they're entitled to those improvements and damages and attorney's fees. Not under Texas law, Your Honor. The good faith improver doctrine is an equitable one that prevents such unjust enrichment. It's such a popular doctrine, Your Honor, that they've considered adding an exhibit at the State Fair of Texas or Six Flags honoring it. I'm just kidding. But it is a very old and lauded doctrine that does predate our state. Cleveland and Perez are good faith improvers here, and the only issue that remains for trial is the value of the improvements. Really, Your Honor, what we're trying to do here is to whittle down the issues so that rather than have a 5-witness trial, we can just have a single issue be tried before you.
All right, response?
Good morning, Judge. This is a fairly simple case, and to take these one at a time, in theory, we don't object to Mr. Cleveland and Mr. Perez at some point being reimbursed for the value of improvements on the property. In fact, we've been trying to offer them a lien to that amount. We've just never been able to get them to give an amount, and we think that that's something that will probably come up at trial. However, at this point, the defendants are asking for a summary judgment that's equivocal. They haven't offered proof of what the statute requires. The statute first requires, well, the council showed you the language of the statute itself. A defendant in a trespass to try title action who is not the rightful owner of the property, but who has possessed the property in good faith and made valuable improvements. To date, there hasn't been any determination by the courts that Mr. Cleveland and Perez are not the rightful owners. Now, we believe they are. And if at some point council wishes to enter into an agreed judgment as to that, then that would certainly shorten things. But her statement today that is undisputed is not reflected in the pleadings. In defendants' original answer, indeed in their amended answer, they have continued to plead a general denial that they deny, each and every, all in singular, the averments made in the petition. In their counterclaim, they have again alleged that if it is found that plaintiffs are the proper owners and that defendants are not the rightful owners, then they are entitled to. Counsel is trying to put the cart before the horse and wants the judge, is looking for a judgment that if it is proven that Cleveland and Perez do not own the property, and if it is proven that they made valuable, that the defendants, that's what the statute says, that the defendants made valuable improvements to the property. And if they are able to determine the value of those improvements, then the court wants to say that they're entitled to a judgment. That's just an awful lot of ifs for a summary judgment order, Your Honor. Counsel has alleged that Cleveland and Perez made valuable improvements to the property, and that is indeed what is required by the statute. There is no evidence that the improvements made by Mr. Cleveland and Mr. Perez are valuable. Now, I anticipate they'll be able to do that. They apparently put in a dog run or something after they moved in.
Well, let's deal with the first issue there, which is really, has there been a determination that your client is not the owner at this point, Ms. Hyken?
So, Your Honor, the entire basis for the action that the plaintiffs have filed is that there's a forgery in the chain of title, and that we have conceded.
In what way have you conceded it, though? Have you?
In our motion for summary judgment on page 1, we concede that, in fact, Mrs. Dora.
Is that consistent with what's in your pleadings?
Yes, Your Honor. There's nothing inconsistent about those facts.
Your Honor, we can pull up the answer, the amended answer, and the counterclaim, and they all deny the facts and demand strict proof thereof. The last one of those is the defendant's counterclaim, and it says,
and I'm happy, Your Honor,
if it is found or determined that the deed was forged. So they're, at least until this morning, they have been challenging those facts, which they have every right to do, but it just seems silly if we're trying to save time for the court.
Your Honor, that's a fact that's been admitted by the plaintiffs, so it's not contested by the plaintiffs, and we have admitted it in our motion for summary judgment. So we have judicially admitted that, in fact, Mrs. Dora Mae Thompson Jones had died in 1998 and could not have signed a deed in 20.
What if we made a stipulation here on the record that there's an agreement that the deed was forged, that they're not the good faith, or they're not the rightful owners?
Yes, Your Honor.
Mr. Watson, do you want to stipulate to that?
Well, absolutely, Judge. That's part of the basis of our case, is that they are not the rightful owners. Of course, we'll have to establish that we are.
So you stipulate there. You stipulate.
Absolutely, Judge.
All right. So that fact is now stipulated. Okay. So let's go to the next issue, Mr. Watson.
So if they are not the rightful owners of the property, then they still have to prove that the defendants, is what the statute said, made permanent and valuable improvements. And although they've made some allegations about some things that they did on the property, there's simply no evidence that the things that they did raised the value of the property. Now they try to bootstrap their argument in by saying, well, the guy before us made some improvements, and then we paid more for the property than he did. But that's not what the statute says. The statute says a defendant who is determined not to be the rightful owner, who has made valuable improvements. The defendant has made valuable improvements. And although there's some evidence that they've done some construction on the property, there's no evidence that it's raised the value of the property.
Have you presented any evidence that indicates that they haven't?
No, Your Honor, this is their claim. I haven't.
Right. I mean, but it's a motion for
provided-
summary judgment, right? So it's a motion for summary judgment. They've claimed they've made
Yes.
valuable improvements. Have you?
There's no evidence.
Contrary. Have you made any presented any contrary summary judgment and evidence to indicate that they haven't?
Judge, I don't believe there's any. I don't believe there's any evidence. No, I don't believe there's any evidence in the record that shows that the stuff that they did not improve the value. Just like there's no evidence that it did.
Mr. Watson, anything else?
Your Honor, as to the I'm sorry, as to the offset issue, Judge, we think that's probably fairly minor. I don't know that we will offer evidence as to the rental value of the property during Mr. Cleveland, Mr. Perez's occupation. However, speaking of law that goes back time immemorial, on the other side of the butter sculpture at the fair is the premise that in trespass cases, offering proof of the monetary value of a trespass is not necessary in order for the jury or the judge in this case to find that value. There's innumerable cases of the hunter going on property. He doesn't take anything, but he is found liable for trespass, and a jury being able to award damages. People going onto property and partying or whatever.
Is this in your summary judgment?
Yes, Judge.
Briefing?
Yes, Judge.
It is? Okay. Do you agree, Mr. Hyken?
No, Your Honor. This is not a trespass case. As we discussed, Chapter 22 limits the plaintiff to an offset for use and occupation of the property, which is, in other words, the rental value. And that rental value, it says, excludes the use and occupation arising from defendant's improvements or those under whom defendant claims. So in other words, the rental value of the house, Your Honor.
I get it.
Yes.
Mr. Watson, what was on the attorney's fees issue?
Your Honor, on the attorney's fees issue, I think Ms. Hyken just said this is not a trespass to try title case. I disagree with her. It is in part a trespass case, but there are a number of ways the court could award part of what the plaintiffs are asking for here and not quiet title in the plaintiffs. The court could find, as apparently Ms. Hyken has now today stipulated, that the deed from Dora Mae Jones is fraudulent and still not quiet title in my clients. The court could find that one of the subsequent deeds are invalid and still not find title in my clients. The court could.
What do you have any causes of action that are currently live that allow for the recovery of attorney's fees?
Your Honor, just our declaratory judgment for findings that the number one, declaring that the plaintiffs are the rightful owners. That's one. Number two, declaring that the original deed from Dora Mae Jones is fraudulent. Number three, claiming that the intermediary deed is fraudulent, and four, that the deed, the final deed to Mr. Cleveland and Mr. Perez are fraudulent.
Okay. So Ms. Hyken, is it your position that with this stipulation, there's no longer a need for a declaratory judgment?
Well, Your Honor, I think my argument on the declaratory judgment action is a very simple one, which is in, again, Sandy versus Powell and many of these other cases that we've discussed. this is very common, let me say, for plaintiffs to try to use the declaratory judgment action to get attorney's fees where possession and title to the property and clouds on title are at issue. So this issue comes up a lot in cases. So let me just sort of quote the relevant portion of Sandy versus Powell. A declaratory judgment action may not be used solely to obtain attorney's fees that are not otherwise authorized by statute or to settle disputes already pending before a court. So in other words, Your Honor, here the dispute about title, possession, and clouds are already pending because they're part of the trespass to try title and declaratory judgment action. And then it goes on to say attorney's fees are not available in a suit to quiet title or remove cloud on title. Any suit that involves a dispute over the title to land is in effect an action in trespass to try title, whatever its form. Because a claim for declaratory judgment is merely incidental to the title issues, the Texas Declaratory Judgment Acts will not supplant a suit to quiet title.
What case are you reading from?
This is the Texas Court of Appeals Dallas case, Sandy versus Powell, which is cited as 153 Southwest 3rd, 736.
Mr. Watson, how do you distinguish that case?
Your Honor, I don't have that case right here in front of me. I can distinguish the two different types of cases just this way. Number one, in the cases that talk about claims that are already pending for the court, we're all aware, and as trial lawyers, we've all done it. Those are the cases where the plaintiff has already pled something, and the defendant comes back and pleads, for declaratory judgment. Oh no, I didn't, and give me attorney's fees. And we've all tried it, and it always fails, and properly so. In the other cases, those cases are where the sole issue is quieting title. Here there are separate issues. There are ways that the plaintiffs can get can recover a partial judgment from Your Honor without actually achieving a title. And again, for instance, the court could declare the deed from Dora Mae Jones to be fraudulent and still not award my client's title, in which case my clients have succeeded in their declaratory judgment claim, but have failed in their trespass to try title case.
All right, I'm going to go ahead and grant summary judgment on all grounds requested by the Ms. Hyken. Go ahead and prepare an order for me, Ms. Hyken. This was at the beginning of the order. Make sure it says that this was heard on September 26, 2022. Go ahead and share a copy of that order with Mr. Watson. I'd like the order by 9 a.m. tomorrow morning. So go ahead and do that today, Mr. Watson. You'll have 2 business hours, work hours to make any comments you'd like to. Any questions?
Judge, I have Ms. Hyken's at least draft of her order. And I would point out that in the order claims to establish that the plaintiffs are liable. There's essentially 2 problems with that, Your Honor. Number one, there has not been a determination, although Ms. Hyken has conceded now that the original deed is invalid. She has not conceded that my clients are the proper owners, number one. Number two, there is simply no language in the statute anywhere that says the plaintiffs will be liable. The only places the words liable are used in the statute are referring to the defendant. What the defendants are entitled to, it's not a lien because the statute doesn't say lien, but what they're entitled to is this procedural mechanism whereby they can fix the value of the improvements they've done and then be reimbursed for those later on from the value of the property, essentially. But in no way does the statute authorize any finding of liability against my clients, again, who have yet to be determined to be the rightful owners of the property.
But it doesn't matter if they're the rightful owners. The issue is that Ms. Hyken's clients are not the rightful owners, right? It doesn't necessarily mean that. I guess.
Yeah, sure. And so if my clients are not the rightful owners, Ms. Hyken's going to have a judgment against them if you sign this order saying my clients are liable, even if they're not the rightful owners. They're just people on the street who happen to point out that Cleveland and Perez didn't own the property, and so now they've become liable to pay for Mr. Cleveland and Mr. Perez's house.
Is there somebody else here that is there somebody else that's a possible owner besides your clients?
Your Honor, there's Trace Tres Benediciones, there's Manuel Leon Posada. There's any one, but not all of my clients. But again, even if they are determined to be the owners of the property, there is simply no mechanism in the statute for finding that they are liable. There is essentially this process for a lien against the property, which if it's not paid in the first year, then the defendants get a right to essentially buy back the property. But there is no mechanism, as Ms. Hyken showed you in the statute, there is no mechanism for finding of liability against the plaintiffs.
Ms. Hyken.
I would be, let me offer this. What if we state that their title is conditioned on payment?
No, that's not what the statute says either. The statute says if my clients get title,
You guys work out language
Work it out, Your Honor.
that corresponds with the statute and the case law, and then just get that to me, okay?
thank you,
Yes,
Judge.
Your Honor.
Thank you, guys. Bye-bye.
Thank you.
Have a good day.